Today's topic, declaratory suit. What is declaratory suit? I am going to discuss about declaratory suit section 42 of the Specific Relief Act 1877. Arranging cause of actions of land property and any other person denied the title or right of possessions, and the person who are aggrieved or who is aggrieved when the creations are denied or interested the title of the property, and the person has an opportunity to create or to file the suit, declaration suit. Actually, a person has a title or right to property and which is denied or interested to be denied by any other person, and arranging cause of actions, the aggrieved party has options to file declaratory suit. On filing the declaratory suit with further relief positions of the suit, otherwise merely file declaratory suit. After that, this suit will be not maintainable because this is not competent claim or demand or remedy before honorable court. And thank you every viewers, and thank you every all who are connecting or joining with live session and listening and watching me, and I would agree or appreciate with gratitude, and this is the great opportunity for me because with your supporting. And discuss with example number 1. A is the owner of the property, but B another party and claim there is no title of A of the property, and A has options or creations or arranging cause of action for the purpose of the land property and with relevant documents, because we know that thousands of defects in documents for the purpose of the civil suit, but relevant documents, chain of title, CS, SA, RS, city, and another deed which is very relevant and submitted before the court, because A is the owner of the property and he was in the possessions of the property. There are two types of ownership. Number 1, by inherent, by or by buying the land or the land property, and have to prove the ownership submitting relevant documents of the dispute land, which is very necessary documents because porcha or documents CS, SA, RS, city or BDS, BRS, and mutations are necessary or relevant deed submitting, and he was in the possessions of the property, but another person have to claim against the property or against him there is no title of A because creation's burden of proof and section 101 of the Evidence Act. Because there is no options and burden of proof on the pleadings never shifted. Because this is the constant and remain constant. Actually, land property, it is you demand and you remember that with relevant documents by inherent, but another party want to claim or going to claim there is no title because he exchanged the property from third party, and this is creation's burden of proof, section 101 of the Evidence Act, because submitting relevant documents before the court and court can decide this is the real or original documents, provide that and find out the ownerships of the property or dispute land. Because only for the purpose of the suit, allegations will be not competent without submitting relevant documents on behalf of that person. Because this case will be maintainable, having demand with further relief for the purpose of the injunctions and for possessions of the property, recovery of possessions of the property. This is the important part of the suit because this is the civil suit. I hope that my lecture will be clear and my lecture will be helpful for you and for your family, and you believe that my lecture will be help and to assist you or your family and to secure your family and to secure your life or your property. Kindly share my lecture and to your family or to your friends who are getting injustice or disposed from the on his land or property. Actually, arising cause of actions of the property, creation's right to file the suit, section 42 of the Specific Relief Act 1877, because only submitting relevant documents of the land property, CS, SA, RS, City, BS, this is more important, mutations necessary, submitted necessary, and this is necessary to submit before the court. Down to the court, find out and analyze the documents, and on the pleadings, the plaintiff demand or filing the declaratory suit with further consequential relief. Otherwise, only for filing the declaratory suit, because this allegation or demanding, this is not competent before the court and not maintainable the suit before the court. Two kinds of declaratory suit. Number one, regarding legal character. Number two, regarding any right to property. Actually, two types of the declaratory suit. Number one, regarding legal character. Number two, regarding right to property. Legal character means because there is no specific defined in the law, but from the many cases and the source of the case about declaratory suit, actually the creations or the arising or cause of actions and creations right to file the declaratory suit, but another or more subsequential relief and with declaratory suit, that this case will be maintainable before honorable court because further requiring or demanding the relief with pleadings. We know that first time one party filing the declaratory suit with pleadings and against the defendant because A is the plaintiff of the case and another party B is the defendant of the case, and B defendant get the summons served by the A through the honorable court, and B defendant appear by appointed his lawyer and submitting written statement, and submitting written statement because denying the relief, because on behalf of the plaintiff it will be denied by the defendant, otherwise accepted the relief or demand on behalf of the plaintiff. Actually, another party or any party claim there is no title on behalf of the party or plaintiff. Plaintiff has right to file the declaratory suit before the court with submitting with relevant documents and on the pleading connected further consequent relief for injunctions, granting the injunctions, otherwise destroy the property and exchange the property to any other person, and the plaintiff is harmful or was harmful for exchange the property by defendant to any other person, because declaratory suit is most important. Section 42 of the Specific Relief Act, and creation burden of proof, section 101, because demand I have a title or right to property, this is the burden of proof, section 101 of the Evidence Act, and burden of proof on pleadings never shifted because remain constant of burden of proof. I hope that my lecture will be helpful for you and for law students or advocates who are practicing in lower court or in high court divisions. I am Advocate Sharul Kumar Rai, Supreme Court of Bangladesh, and I am founder and director of Sharlok Academy. And coming soon, and 12 June 2026, ready for exam Bar Council preliminary exam. Wishes everyone from Saral Academy and get your success in your life being advocate, and you can effect or give something or care your family, care yourself, and get happiness with your family and time pass with your family, with your own self. Actually, after creations or arising cause of actions ready for suit, because the aggrieved party has a right to file the declaratory suit. But remember that when he will file the declaratory suit, have to connect or wanting list further relief. Otherwise, after filing declaratory suit, only the case not maintainable or not competent before court, because there is no option to demand further relief on the pleadings, because submitting the pleadings and started file or suit and you lost your opportunity or you get unjusted justice, because this is the fault of you, and careful demanding or to file the declaratory suit with connected with further relief, then this case will be maintainable before the court and there is more chance to get the remedy before the court. Legal character of any person is denied or interested to be denied by any other person. The aggrieved person can file declaratory suit at the same time. Any person having any right to property may file declaratory suit against any other person by whom which right is denied or interested to be denied by that or that person. It is the general principle of civil suit that there may be thousands of defects in the documents of the defense as well as in their case, but that does not entitle the plaintiff to get a degree. The plaintiff has to prove his case irrespective of defense version. This principle has developed following the provisions of Section 101 of the Evidence Act. Because arising civil suit, aggrieved party, the person who is aggrieved party and called him plaintiff, and arising to file of declaratory suit, but there is the burden of proof effect on behalf of, because burden of proof on the pleading never shifted, because this is the remain constant of burden of proof. Submitting relevant documents, because demanding or regarding the legal character of the property. Number two, regarding the right to property, which is very essential for the purpose of the suit, because as well as the declaratory suit. This is the main issue of the case. It will be analysis by my lecture. I hope that my lecture will be help or to assist your career or your life. The person who are advocate or law students practicing in lower court or high court divisions. And I am Advocate Sharul Kumar Rai, Supreme Court of Bangladesh and founder and director of Sharol Academy. And every student cannot get the success being advocate in your life. Kindly contact me and confirm your seat. And we offer for written batch of Bar Council. I hope that first time get the success in your life being advocate in the society. I hope that and maintain the routine of Sharol Academy. Further relief contemplated by the provisions to section 42 is relief against the defendant only, where the defendant is not in a position to deliver positions to the plaintiff. Prayer for positions need not be claimed. In the case of attachment under section 146 and it is CRPC, it is stood before it amended in 1955. A suit for mere declarations without prayer for delivery of positions is competent. Actually, alleging cause of actions, plaintiff is aggrieved party of the land property because dispute land property, and plaintiff can file the suit of declaratory suit and on the pleadings connected with that further relief. Then filing declaratory suit will be maintainable before all the court, because the plaintiff has more options to get the relief before the court for the purpose of the dispute land or property, because another party interested or denied by him and there is no title or legal character or right to property of the dispute land, and plaintiff has options to file the declaratory suit with further consequential relief before the court. This is the opportunity or the options to get the remedy before the court, and submitting relevant documents by a deed. All documents or deeds. Number 2, CS, SA, RS, CT, BS. This is the most important, and submitting mutation. Analyzing those documents of the suit for the purpose of the declaratory suit, the honorable court can decide that because the plaintiff will be owner of the property because has the burden of proof, section 101 of the Evidence Act, and the court or law prefer that there is no options to change the burden of proof or on pleadings, burden of proof on the pleadings never shifting or shifted, because this is the burden of proof and it will be remain constant of burden of proof. I hope that my lecture will be helpful for you, and thank you to all persons who are connected or joining with live sessions. I hope that sometimes I have not to cover the time daily routine, not maintain to daily routine, because I am regular practitioner in High Court divisions and sometimes practice in lower court. So cover or maintain the time, it is so difficult sometimes for me. So I am so sorry, and I always come back or join actually after 10 or 10:30. Then my viewers joining with the live sessions and watching and listening me, thank you very much. This is the great opportunity for my life, and I hope that I do better in my life with your supporting. And today's topic is declaratory suit, section 42 of Specific Relief Act, and creation and other sections, burden of proof 101 of the Evidence Act. And number 3, two types of declaratory suit. Number 1, regarding the legal character. Number 2, regarding of right to property. And another party interested denied the title of the property, and the aggrieved party is the plaintiff, has the options to file the declaratory suit against defendant. Defendant means who are denied or interested to be denied the title of the property. This is the reality or real practice in lower court or high court divisions, and the students who are preparing for bar council MCQ, I provide that the suggestions of bar council preliminary, previous questions completed. I hope that previous questions solving, this is the came or coming in your life as a good opportunity to win in from the exam or being advocates in your life. And short topic or short suggestions, previous questions will be find out or analysis or covered by you. I hope that it will be help to win or get the success and being advocate in your life. And thank you very much. I am Advocate Sharul Kumar Rai, Advocate Supreme Court of Bangladesh, and founder and director Saral Academy. And thank you to all viewers, senior and juniors, my learned friends, my colleagues who are joining with live sessions, and with me. and watching and listening me. Thank you very much. Namaskar.